Good morning. I'm slightly conscious that some of the delegates here will be very familiar with what I'm going to talk about. That's to say, those of you who work in the UK, others it will be quite, it won't be so familiar. So I'm going to pitch it at a fairly basic level. The Competition Appeal Tribunal, as you have heard, is a specialist UK tribunal which decides cases involving competition or economic regulatory issues. An increasing proportion of the tribunal's workload consists of collective proceedings. Collective proceedings were introduced into the United Kingdom following the amendments to the Competition Act 1998 in 2015. They may be brought on either an opt-in or opt-out basis. Opt-in proceedings require the representative parties to take proactive steps to participate, whereas in opt-out proceedings, a claimant represents a group of people without needing to identify them or get their permission. This legislative change effectively established a US-style class action regime in the United Kingdom for the first time. Collective proceedings really took off in the United Kingdom following the landmark decision of the Supreme Court in Merrick's against MasterCard in 2020. The claim in those proceedings followed on from the finding of the European Commission that MasterCard had infringed European competition law as a result of interchange fees on transactions over a 15-year period from 1992 to 2007. The Supreme Court held essentially that the great diversity within the class represented by Mr. Merrick's and the difficulties of assessing the losses of individual consumers were not valid objections to the use of the collective proceedings regime. Since then, the number of collective proceedings before the tribunal has increased exponentially. As of this month, there are over 50 pending collective proceedings in the tribunal. These include claims against utility providers, car and truck manufacturers, banks and tech giants, notably Apple, Facebook and Amazon. There are other ways of bringing group proceedings in the UK courts, notably via representative proceedings or group litigation orders, but the collective proceedings regime is considerably more sophisticated and more widely used than those other procedures. Turning to funding. Litigation funding is, of course, essential to the success of the collective proceedings regime, as the courts have repeatedly recognised. It will rarely, if ever, be a wise use of limited resources for a consumer to litigate a competition claim alone. The disparity between the significant cost and effort involved and the modest amount of damages recoverable would be too great. Litigation funding promotes access to justice and facilitates equality of arms between consumers and businesses. The decision of the Supreme Court in the well-known case of Packard, from which I gather you've heard a lot already, called into question the validity of a significant number of funding agreements supporting collective proceedings. The Supreme Court decided that a common form of third-party funding, under which the funder's payment in the event of success is calculated as a percentage of the damages recoverable by the funded party, fell within the scope of the regulations that govern damages-based agreements, or DBAs, and was consequently unenforceable. It is to be noted that the Supreme Court reached its decision on the basis of the wording of the relevant legislation, rather than on the basis of any policy objection to litigation funding. Unsurprisingly, therefore, the previous Conservative government intended to legislate to clarify that funding agreements did not come within the scope of the DBA regulations, but the bill was not enacted before the general election. The new Labour government has made clear that it does not intend to reintroduce the 2024 bill, but intends to consider more wide-ranging reform of the legislation relating to funding of group litigation. It has commissioned advice on the subject from the Civil Justice Council, which is an advisory public body. The CJC recently issued an interim report with details of a consultation exercise to be completed by July next year. The interim report recognises the potential problems with third-party funding, including the scope for conflicts of interest between funders and represented parties, and the problem of excessive fees. At the same time, the report acknowledges the importance of third-party funding to group litigation and the need for funders to earn a profit, and the possibility that market forces may be sufficient to act as a constraint on the level of funders' remuneration without the need for regulatory intervention. It seems unlikely at this stage that the CJC will recommend particularly prescriptive regulation of funding, particularly given that the European Law Institute has recently produced a report on third-party litigation funding written by a team co-led by Mrs. Justice Cockrell, who is also a member of the CJC working group. The European Law Institute's report recommends a series of principles such as the need for transparency and capital adequacy. These are general principles which may or may not be incorporated into legislation by individual states. Pending further legislative developments, funders have revised their funding arrangements so as to avoid them being unenforceable under PACAR. In several recent cases, the tribunal has held that where a funder is to be paid a multiple of funding rather than a percentage share of damages, this would fall outside the statutory prohibition and therefore be enforceable in opt-out collective proceedings. Turning to the tribunal's control of funding. The funding arrangements entered into by the class representative and the funder, including the fee payable to the funder, are subject to the oversight of the tribunal at all stages in the proceedings. First, at the outset, a class representative must apply for permission in the form of a collective proceedings order in order to bring the claim. The tribunal's role at this stage has been described as that of gatekeeper. Under the relevant statutory provisions, the tribunal must be satisfied that it is just and reasonable for the proposed class representative to act in that capacity. And this will include a review of the funding arrangements. However, the tribunal will not generally concern itself at this stage with the fee payable to the funder. Its primary concern will be to ensure that the class representative will be able to pay the costs of the class representative and the prospective defendant's recoverable costs if ordered to do so. Second, the terms of the funder's remuneration will be scrutinised if and when a settlement is reached in opt-out proceedings. Before approving a settlement, the tribunal must be satisfied that the terms of the settlement, including provision for payments of costs and the funder's fee, are just and reasonable. In a recent decision in the maritime car carriers proceedings, the tribunal held that it has jurisdiction to approve the payment of a litigation funder's fee pursuant to Rule 94 of the tribunal rules, which is particularly concerned with settlements, and also Rule 53.2, which sets out the tribunal's general case management powers. The final stage in the proceedings, when the tribunal will pay special regard to the funder's fee, is when it makes an order for damages following trial in opt-out proceedings, and there are unclaimed damages left over. In that situation, the damages must be paid either to a prescribed charity, or they may be paid to the class representative in respect of costs and expenses incurred by the representative, including the funder's fee. In exercising its discretion to order any such payment, the tribunal may itself determine the amount to be paid, or it may direct that any amount be assessed by a cost judge. In the Merrick's case, the tribunal observed that the tribunal could, if necessary, hear evidence as to what would represent an appropriate return to the funder. How would the tribunal approach its oversight of the funder's fee? As yet, the tribunal collective proceedings regime is in a state of relative infancy. There have been the first 2 settlement approvals this year. Neither ruling touched on the quantum of the funder's fee. Judgment is currently awaited in the first case to go to a full trial. There is therefore little by way of case law guidance. It is nevertheless clear from the observations of the tribunal and the Court of Appeal in a number of cases that there are 2 basic considerations that the tribunal will bear in mind if called upon to exercise control of a funder's fee. On the one hand, there is the potential need to ensure that funders' fees are not excessive. Funders are, for the most part, commercial investors whose dominant interest is to make money on their investment from the fruits of the litigation. There is scope for the cost of funding to spiral out of control relative to likely awards. Class representatives may not have a strong incentive to shop around or obtain independent advice on the funding package offered by a particular funder. On the other hand, the tribunal recognises that it is entirely legitimate for funders to seek a return on their investment. Funding will dry up if funders are unable to make a sufficient profit. The tribunal should therefore be slow to second-guess the commercial decisions made by competently advised class representatives and should, as far as possible, leave the market to regulate itself. I would like to draw your attention to 2 recent cases in the tribunal which are informative on the question of the funder's fee. The first is the case of Gormson against Meta Platforms, in which a claim is being made for over £2 billion on behalf of 45 million Facebook users in respect of Facebook's alleged abuse of a dominant position in its imposition of trading terms and its use of personal data. The tribunal observed that funding gives rise to at least 2 issues in relation to which the tribunal must exercise great care. I should say that this ruling was made at the stage of the application for a collective proceedings order, right at the start of the proceedings. First, there is the question of whether a funder is taking more from the class than it properly should. Second, there is what the tribunal referred to as a danger of perverse incentives arising, in other words, a conflict between funders' interests and class interests. In relation to perverse or divergent incentives, it should be noted that an unintended consequence of the Packard decision is that the interests of funders and the claim representative are no longer aligned as they would be under an arrangement in which the funder is entitled to a share of the damages recovered. For example, if a funder's remuneration is not fixed by reference to the level of the class's recoveries, the funder may have an incentive to sue and settle quickly for a sum which is materially less than the likely aggregate award. This would risk undermining the policy objectives behind the legislation, which include properly rewarding the class and creating incentives for undertakings to comply with competition law. The tribunal recognised in Gormson that funding arrangements are a matter of commercial negotiation between the class representative and the funder, into which the tribunal should be slow to venture. But it also said that the tribunal would be astute to ensure that a system intended to further access to justice does exactly that, and does not become a cash cow either for lawyers or for funders. The tribunal considered that funding arrangements might be so extreme as to justify calling out or even a blanket refusal to certify. The tribunal was of the view that the funding arrangements initially proposed in that case did indeed need to be called out. The arrangements involved a ratcheting up of commission depending on the date of judgment or settlement. Using hypothetical figures for reasons of confidentiality, the tribunal considered that a commission return of 350 million or 3.8 times the level of exposure after 1 year was defensible, whereas a return of 750 million, being 8.3 times the level of exposure 21 months later, was extreme and excessive. An interesting feature of the Gormson decision is the observation of the tribunal that it could see no justification in withholding the terms of the funding arrangements from public scrutiny and could see considerable benefit in disclosure. A regime built around access to justice ought to be as open as possible, including in particular as to the price that is paid, admittedly indirectly, by the class on whose behalf those claims are ultimately brought. This issue of confidentiality is one that is likely to be a bone of contention in future cases. So the Gormson case provides some general guidance as to how the tribunal is likely to approach the level of funders' fees. The second recent case I wanted to mention addresses an important issue for funders, namely whether their fee can be paid out of undistributed damages or whether it can be paid out of damages awarded prior to payment to the class members. In Gutmann against Apple, a claim is being made on behalf of 26 million iPhone users in relation to Apple's alleged concealment of defective battery issues. The funding agreement includes a mechanism for the funder's fee to take priority over the payment of damages to class members. At the application for a collective proceedings order, Apple argued that this was not permissible and that the funder's fee could only come out of unclaimed damages. The tribunal disagreed. The fee could be paid out of damages prior to payment to the class members. As the tribunal noted, there is no express prohibition in the Competition Act or the tribunal rules preventing the funder's fee from being paid out of damages. Self-evidently, a funder must be paid for the risk it takes. If a reasonable return was dependent upon the mere chance that there was sufficient unclaimed damages left over, that would potentially increase the risk for funders and consequently the cost of litigation funding. The ruling is subject to appeal, but in my view, it is welcome. It would be unsatisfactory if funders could only recover their fee from unclaimed damages. If that were the position, funders would only be willing to fund cases where there was bound to be sufficient unclaimed damages to cover their fee. This would undermine the compensatory aim of collective proceedings and would deter class representatives from devising efficient distribution arrangements. For example, arrangements under which the entire award of damages is automatically credited to consumers' accounts, leaving little or nothing left over. It would, on the contrary, encourage inefficient distribution plans guaranteeing sufficient funds left over to pay the funder's fee. An important point to reiterate is that any payment to funders out of damages will be subject to approval of the tribunal prior to payment. Thus, although this case makes it clear that payments out of damages are possible, they would be subject to the tribunal's power to balance the competing interests of funder and class at the appropriate moment. The tribunal's ruling in Gutmann is therefore, in my view, good news for funders and for class members. In conclusion, it seems likely that the UK market for litigation funding and collective proceedings will continue to grow, despite the uncertainty caused to funding arrangements by the Packard decision. It is to be anticipated that as the market develops, a fully functioning competitive market for litigation funding will emerge. The more demonstrably competitive the market becomes, the easier it will be for the tribunal to stand back from detailed examination of the funding arrangements in individual cases. The tribunal will continue to clarify the legal principles relating to funding arrangements. In that process, it will be astute to ensure that collective proceedings do not become a cash cow for funders and lawyers with minimal returns to class members. But at the same time, it will be slow to interfere with funding arrangements freely negotiated between funders and class representatives. Thank you very much.